Okay, ladies and gentlemen who are interested in studying for the New York State exam for licensure to become a real estate salesperson, we are going to continue from where we left off just the other day. I might try to keep it a little quieter today because I'm actually sitting in my car with my 4-year-old sleeping in the back. He's taking a nap. He didn't really sleep last night that much, so he fell asleep in the car and he needs his nap. So we're going to continue from where we left off last time in our book entitled Modern Real Estate Practice in New York for Salespersons. The license law prohibition against sharing a commission with any unlicensed person does not prohibit a real estate agent from rebating part of her commission to a seller, buyer, landlord, or tenant, as long as this is done as a business incentive and not as a payment for any activity that requires a real estate license. If the recipient is not the broker's client, then such payment should be disclosed to the client, who should be asked to give her conformed consent. Many times I've spoken to one particular real estate agent who is very successful in Brooklyn, New York, and he tells me how he rebates his commissions all the time to make deals go through. He'll, give sellers a break quite often. He'll pay buyers for things through his commission, and that's legal so long as it's being given to, like we said, a buyer, landlord, or tenant as a business incentive and not as a payment for any sort of negotiation that would require a real estate license. Generally speaking, compensation paid by or to a real estate agent is considered improper when it is done without full disclosure and informed consent. When a licensee receives payment from another licensee or from another party, such as a mortgage professional or title insurance company, for referring business, for this is to be considered a legitimate referral fee. The party being referred must have agreed to be referred, and the party being referred must have been given full disclosure about and must have granted informed consent to the broker's receipt of a referral fee or other valuable consideration. Let's read that again, because I'm not exactly sure what that meant. Generally speaking, compensation paid by or to a real estate agent is considered improper when it is done without full disclosure and informed consent. Okay, that makes sense. When a licensee receives payment from another licensee or from another party, such as a mortgage professional or a title insurance company, for referring business, for this to be considered a legitimate referral fee, the party being referred must have agreed to be referred, and the party being referred must have been given full disclosure about and must have granted informed consent to the broker's receipt for a referral fee or other valuable considerations. So that also makes sense. So in other words, what we're saying is, in order for me as a licensee to receive a referral fee from another licensee, the one who's the client who's being referred needs to give full consent and needs to have full disclosure that he's being referred, and must have granted informed consent to the broker's receipt of a referral fee or other valuable consideration. When the party being referred by the broker is not the broker's client, then that client should also give informed consent. The license law expressly prohibits a broker or salesperson from first demanding, after the fact, the payment of a referral fee once a listing agreement, buyer representation agreement, or contract of sale has already been signed. A real estate broker or salesperson who engages in property management activities must not accept rebates or commissions on expenditures made in managing a property without the client's full consent. A kickback is illegal and will subject the licensee to disciplinary action. A commission rebate paid by or a referral fee accepted by a real estate broker, given the appropriate procedures, falls within the law. It is important to note that for licensees, all referral fees are treated as compensation. As such, all compensation must go directly to and through the broker. Licensees within the employ of a broker may never collect compensation of any kind directly from anyone other than their sponsoring broker. Licensees may neither buy nor acquire any interest in property listed with them for their own account without first making their true position known to the owners involved. Similarly, licensees may not act as brokers or salespersons in the sale of property in which they have an interest without revealing the interest to all parties to the transaction. When self-dealing, the licensee must be on alert for the potential creation of a dual agency. At any time during the transaction, all offers to purchase property must be presented promptly to the owner of the property, even if the property is under contract. This is to be done unless the seller specifically states not to do so. Advertising must not be misleading in any way. All real estate advertisements must contain the name of the broker's firm and must clearly indicate that the party who placed the ad is a real estate broker. Any ad that does not identify that the advertiser is a real estate broker is termed a blind ad and is prohibited. On websites, as well as in print ads and on business cards, a salesperson's name may not be displayed more prominently than the broker's or firm's name. Any internet ad must contain a link to the firm's website. The broker must supervise a salesperson's website. All advertisements that state that a property is in the vicinity of a geographic area or territorial subdivision must include as part of the advertisement the name of the geographic area or territorial subdivision in which the property actually is located. A broker must obtain an owner's prior consent to place a for sale sign on the owner's property. Neglecting to do so is considered an infraction of license law and will subject the licensee to disciplinary action by the Department of State. Any of the following acts can be found to constitute untrustworthiness or incompetence on the part of a real estate licensee: making any substantial misrepresentation, making any false promise like to influence, persuade, or induce, making a false statement or misrepresentation through agents, salespersons, advertising, or others, accepting, if a salesperson, a commission or valuable consideration for any real estate service for any person except the licensed broker with whom the salesperson is associated. Let me read that line again. Accepting, if a salesperson, a commission for any real estate service from any person except the broker with whom the salesperson is associated. Acting for or receiving compensation from more than one party is a transaction without the knowledge and consent of all parties. From more than one party in a transaction without the knowledge and consent of all parties involved. Failing within a reasonable amount of time to account for or remit any monies belonging to others that come into a licensee's possession. Failing to immediately deliver duplicate or original documents to an interested party in a transaction. Failing to make the appropriate property disclosures when these defects are known to the licensee. Paying a commission or valuable consideration to any person for services performed in violation of the law. Obtaining a license falsely or fraudulently, or making a material misstatement in the license application. Negotiating with an owner or a landlord with knowledge that the owner or landlord has an exclusive written contract with another broker. Interfering with the agency relationship of another. Offering a property for sale or lease without the authorization of the owner. Accepting the services of any salesperson who is associated with another broker. Giving legal opinions or performing title examinations. Entering into a net listing contract. When a seller authorizes a broker to procure a specified amount of money for the property and allows the broker to keep any money above the specified amount obtained for the sale. Discriminating because of race, creed, color, national origin, age, sex, disability, sexual orientation, marital status, familial status, or military status in the sale, rental, or advertisement of housing or commercial space. Failing to provide definitions of exclusive right to sell and exclusive agency listing in a listing agreement when the listing involves the sale or rental of a 1 to 3 family dwelling. This does not apply to co-ops or condos. Interruption of essential building services by real estate brokers functioning as tenant relocators. Engaging in improper, fraudulent, or dishonest dealing. Committing any other violation of license law. Brokers must follow various laws and regulations as they operate their brokerage businesses. Place of business. Every New York real estate broker must maintain a principal place of business within the state of New York, with some rare exceptions. Any business name used by a New York real estate broker must first be approved by the Department of State. In the typical storefront office, a sign with the broker's name and the word licensed real estate broker must be posted conspicuously on the outside of the building and be readable from the sidewalk. When the real estate office is located inside an office building, apartment building, or hotel, the broker's name and the word licensed real estate broker must be posted in the space that lists the names of the building's occupants. The words licensed real estate broker may be abbreviated to LICE, RE broker. A broker may maintain a branch office or offices, and a separate license must be maintained for each. Section 441A, subsection 3 of Article 12A of the RPL, and Section 175.20 of Department of State Regulations provide that each branch office must be under the direct supervision of the broker to whom the license to operate a branch office was issued. This would be the principal broker, who also holds the license to operate the main office, or when the license is held by a corporation, partnership, or LLC, it would be a representative broker of the corporation or partnership of a manager of the limited liability company. The principal broker must pay expenses for the branch office and supervise it closely. However, an associate broker who obtains a license designating himself as an office manager may operate a branch office under the other broker's overall supervision. Regulations that in the past permitted a salesperson licensed for at least 2 years to operate a branch office have been repealed. Every real estate broker must maintain a file of all agency disclosure forms, listing offers, closing statements, and certain other documents for a period of no less than 3 years. Most brokers keep all records indefinitely as a matter of good business practice. A real estate broker must immediately deliver to all parties signing the document duplicate originals of any document relating to a real estate transaction prepared by the broker or one of the broker's salespeople. Failure to do so may subject the licensee to disciplinary actions by the Department of State. Okay guys, we're going to hold it here for now.